Welcome. In this video, we'll introduce the key documents that form the foundation of an estate plan. By the end, you'll have a clearer picture of the steps you can take to protect yourself, your family, and your wishes. An estate plan is a set of directions that you leave for your family and loved ones, directing them in the event of your death or incapacity. You put this plan in place while you're alive through a set of legal documents. A good plan not only provides peace of mind but also helps protect your assets, reduce costs, and make sure your wishes are followed. When we talk about the foundation of a good estate plan, we mean the core documents that almost everyone should have. We'll walk through those documents, explain how they work together, and finish with a short overview of probate in Massachusetts, the court process that often follows when someone passes away. These are the core documents that make up the foundation of an estate plan. A health care proxy names someone to make medical choices for you. A HIPAA authorization allows doctors to share your health information with the people you trust. An advance directive lets you express your wishes for end-of-life care. A durable power of attorney gives someone authority to handle financial and legal matters if you can't. And a last will and testament directs what happens to your property after you pass away. The truth is, these documents aren't just for older adults or the wealthy. They're important for everyone. Two of the most important estate planning documents are the durable power of attorney and the healthcare proxy. The durable power of attorney lets you name someone you trust to handle legal and financial matters if you can't. The healthcare proxy allows you to choose a person to make medical decisions on your behalf. Many people assume their spouse can automatically step in, but that's not always true without these documents. And parents can't automatically make decisions for their child without a proper estate plan. A durable power of attorney, or DPOA, is a legal document where you name someone to manage your financial and legal affairs if you can't. This can include paying bills, handling bank accounts, or even selling property. In Massachusetts, these powers are very broad, and the document is usually effective as soon as you sign it. That's why it's so important to select only a person you deeply trust to act as your agent. Healthcare documents are just as important as financial ones. They make sure your medical wishes are honored and your family isn't left guessing. A healthcare proxy lets you appoint someone to make medical choices for you if you can't. A HIPAA authorization gives that person, or others you trust, access to your private medical information so they can stay informed. And an advance directive, sometimes called a living will, allows you to put in writing your wishes for life-sustaining treatment and end-of-life care. Together, these documents ensure your voice is heard even if you can't speak for yourself. There are differences between an advance directive and a will. An advance directive or living will states your wishes for medical care if you cannot decide for yourself. An advance directive is not legally binding in Massachusetts, but still very helpful. A will or last will and testament directs what happens to your property after death. You can indicate how you would like to be buried and any special things you would like related to your memorial services. It becomes legally effective once you pass away. A last will and testament is a legal document that makes sure your wishes are carried out after you pass away. Without a will, the state's intestacy laws decide who receives your property, which can create unnecessary complications for your family. A will can do many things. It can give your personal representative the authority to sell real estate, spell out who receives your belongings or money, and provide for children, loved ones with special needs, or even pets. It also lets you name a personal representative, sometimes called an executor, to manage your estate. In some cases, a will can create what's called a testamentary supplemental needs trust, which helps provide for a family member with disabilities without jeopardizing their eligibility for government benefits, such as mass health. Probate is the court process that takes place after someone passes away. In Massachusetts, the court's job is to confirm that the will is valid, appoint a personal representative to handle the estate, and make sure the property is distributed to the right heirs and beneficiaries. While probate is sometimes necessary, many families try to avoid it when possible. That's because it can be expensive, time-consuming, and in many cases takes at least a year to finish. Getting started on your estate plan is easier than you might think. At Surprenant, Beneski and Nunes, we offer private consultations where we take the time to learn about your family, your goals, and your circumstances. Together, will outline the steps you should take now. See whether your current documents still meet your needs, and update or create a plan that gives you and your loved ones peace of mind. We're proud to serve families throughout Southeastern Massachusetts, Cape Cod, and the islands. At Surprenant, Beneski and Nunes, we focus on helping families achieve peace of mind through thoughtful estate planning. No matter your financial situation or family circumstances, the best way to protect your assets and your legacy is to work with a trusted estate planning attorney. Visit myfamilyestateplanning.com to learn more about our team and accolades. Our team looks forward to guiding you through your planning journey. We have offices in New Bedford, Easton, and Hyannis, and we also make planning more convenient by offering Zoom consultations or even meeting with you at your location, such as an assisted living community or the hospital. Friendly disclaimer: this presentation is for illustration purposes only and does not constitute legal advice. Thank you for watching.